Good afternoon. My name is Brad Goldman, and I am Managing Director, General Counsel, and Chief Compliance Officer here at Palisade Capital Management. As your moderator, I'd like to first thank you for taking the time to join us on today's presentation of the Secure Act. Lorraine Salvo, CFP, Palisade's Head of Financial Planning, will speak for about 15 to 20 minutes. If you would like to submit a question during the presentation, please click the Q&A button on your screen, type in your question, and hit send. If you are on the call and for any reason are not able to access the visual presentation, please continue to listen in, as a recording of this webinar will be made available in the coming days. Following the presentation, Lorraine will answer as many questions as time allows. Before I hand over the reins to Lorraine, please bear with me as I read a brief disclaimer. The information contained in this webcast reflects the views of Palisade Capital Management, LLC as of the date of its original broadcast, and such views are subject to change without notice at any time. All information provided in this webcast is for informational purposes only and should not be considered investment advice or a recommendation to purchase or sell any specific security. While the information presented herein, including information obtained from third parties, is believed to be reliable, no warranty is made concerning the accuracy of such information. There can be no guarantee that any forecast discussed in this webcast will be realized. Consult your financial advisor before making any financial planning or investment decisions. Past performance is not a guarantee of future results. Lorraine, you have the floor.
Thanks, Brad. And thanks to everyone for joining us today to learn more about the Secure Act and what it may mean to you. We have a lot to cover, so I will do my best to touch on as many of the key points as possible. So let's get started by asking, what is the Secure Act? It is an acronym which stands for the Setting Every Community Up for Retirement Enhancement Act. This act spans many different areas that affect retirees, and it's important to be aware of these. The Secure Act was signed into law at the very end of 2019 on December 20th and carries with it many significant changes. It is the most sweeping retirement reform legislation we've had in years, and it expands retirement savings options for many retirees. One significant provision of the Secure Act, which you may have heard about, is that you can now contribute to your IRA even if you are over 70 and a half. Previously, contributions could be made up to age 70 and a half, but now you can make them at any age, assuming you have earned income. And according to the IRS, this is defined as wages, salaries, bonuses, commissions, tips, and net earnings from self-employment. And it can also include long-term disability, union strike benefits, and in some cases, interestingly, payments from certain deferred comp arrangements. And this does not include investment income, though, so just keep that in mind. This is terrific news for anyone who continues to work past full retirement age. We live in an age where people are just living longer and working longer, and the definition of retirement has truly evolved. Retirement for some may still mean what it meant to our parents or grandparents. Work very hard for about 40 to 45 years, retire and stop working entirely to enjoy more free time and hobbies, and begin collecting a pension or begin withdrawing from savings. However, the definition of retirement has been blurred. It can now mean working longer, but on your own terms, consulting or serving on boards, and using lifelong skill sets and experience to stay engaged, find purpose, and continue to make an income. Note that in 2020, total contributions to all traditional and Roth IRA accounts cannot be more than $6,000 or $7,000 if you are age 50 or older. Let's switch gears a bit to focus on the RMD changes. Breaking this down, a required minimum distribution, or RMD, which you'll hear a lot about in this webinar, is the amount of money that must be withdrawn from all non-Roth IRA retirement accounts at retirement age. The amount is a calculation based on the retirement account value as of the prior year's end and your life expectancy. You can now delay RMDs to age 72 if you have not already started taking them by the beginning of this year, by 1/1/2020. Note that this change is not retroactive, so if you're already taking RMDs, you will need to continue to do so. Note that RMDs can begin as early as 59 and a half without penalty if you should need the cash flow to supplement your income. Retirees can and do take more than the RMD. The assets are there for you. It's your money to use as you see fit, but just keep in mind that when you take RMDs, it will be counted as taxable income to you. Another big change with the Secure Act is the elimination of the stretch IRA. Previously, under the old rules, you could stretch distributions from an IRA across your lifespan, effectively smoothing out the effect on your taxes. Instead, designated beneficiaries are now required to withdraw the full amount of the retirement account over a 10-year period, called the 10-year rule. However, they're no longer annual RMDs, so distributions do not have to come out every year as they used to. This means the benefits can continue to grow on a tax-deferred basis during the 10-year period, and if you choose, take them in a lump sum at the end of the 10 years. Interestingly, there's no limit on when or how often you withdraw money from the account. So there's an opportunity to do some tax planning here if you determine that it makes sense to take either periodic payments, one lump sum payment in an otherwise low tax year, looking at your other income sources, or some middle ground. Note that all RMDs will be counted as income and subject to taxes in the year you make the withdrawals. But there are some exceptions to the 10-year rule. One, and one of the most popular, is if you inherited the IRA from your spouse. In this case, you can treat this account like it's your own. If it's a Roth IRA, you don't have to take any withdrawals in your lifetime. If it's a traditional IRA, required distributions start when you reach age 72. Under the Secure Act, a surviving spouse who is designated as a beneficiary can stretch the distributions over their lifetime and also may roll these inherited retirement accounts into their own IRAs. If a trust, and this is an interesting provision, if a trust for the surviving spouse's benefit is actually the beneficiary of the retirement account, and this trust is required to pay out only income, such as an income-only marital trust, the trust has to comply with the 10-year rule. If that's not the case, it doesn't necessarily have to be that way. So the nugget here is if you have this situation where there's a trust that is the beneficiary, we are available to weigh in and help you really navigate this because it can be kind of complex. We just want to make sure it's done the right way. Another exception is if you are a minor child. You must start distributions, but they'll be figured based on your life expectancy. This rule applies only until you reach the age of majority, which in most states is 18. That's when the 10-year clock starts ticking and you then have 10 years to withdraw the entire account. There is some concern in reading lots of articles on this topic that this then accelerates, of course, the distribution period for these beneficiaries. And I think that the idea of pairing inherited assets with legacy guidelines in terms of how you view the money, how you earned the money, how it came to you, and what it means to you as you pass it down to other generations can be really meaningful, as opposed to just receiving cash with no other really instructions or meaning associated with it. So it's an opportunity to really also pass down some of what's important to you along with those assets. And if you are chronically ill or disabled, you can stretch the IRA distributions out over your lifetime. Finally, if you're not more than 10 years younger than the account owner, such as if you have a young aunt or uncle from whom you inherit an IRA, withdrawals can be stretched over your lifetime. So now let's talk a little bit about charity and how charitable giving comes into play with the Secure Act. Of course, giving to charity, just like creating a legacy, is a very personal topic. And if you and your family are charitably inclined, a qualified charitable distribution is something that you could want to consider, which offers some tax savings as well. So qualified charitable distributions, or QCDs, as they're called. We have lots of acronyms in financial planning. You may have heard about these or even used them. They have been around for quite a while, since 2006, and they have gained in popularity over the years. They were previously renewed on a yearly basis as a temporary provision, and myself and many of my colleagues every year would wait to see if it was renewed again. And I think the IRS finally just said, let's make this permanent, it's popular, and they did that at the end of 2016. So this is a permanent provision available now. If you have charitable intent and are facing very large RMDs, these distributions from an IRA where you don't actually need the distributions right away to supplement your cash flow, using a QCD could make a lot of sense. The QCD allows all or a portion of your RMD, up to $100,000, to be contributed directly to charity. Interestingly, the SECURE Act did not align the new RMD requirement age of 72 with the age at which QCDs can begin, which remains at 70 and a half. So in other words, you can begin effectively reducing what your RMDs will be when you turn 70 and a half during the period where you can make these charitable distributions and be charitable, reducing future tax liability and a future large IRA that you're looking to draw down. You also avoid being taxed on any income that would have come through as an RMD, because that's ordinary income to you. If it's instead used as a qualified charitable distribution, it doesn't hit your income, so there's some tax savings there. And one important note is that IRA contributions made after age 70 and a half cannot be used as qualified charitable distributions. If you're over 70 and a half and are both contributing to an IRA and contemplating the QCD strategy, it's best to have a conversation with your CPA or your financial advisor to mitigate any potential issues. Another main provision of the SECURE Act for individuals is the expanded use of 529 assets. I get questions about 529s a lot from generous parents and grandparents who are really looking to better understand and maximize the use of these vehicles for college costs. So first, let's just go through a quick summary on 529 plans. What they are flexible tax-advantaged accounts designed specifically for education savings. Withdrawals can be taken to pay for qualified education expenses, now elementary through high school or through college and beyond. So they have become much more flexible in terms of the years that you can use them of schooling. And then when we reach the college and graduate level, 529 plan assets can be used for tuition, fees, books, supplies, study equipment, and room and board for a full-time student at an accredited institution. And when they're utilized for these qualified purposes, there's no federal income tax on the gains that are generated within the 529 plans themselves. So these assets are growing essentially tax-free, compounding for the benefit of funding education for the beneficiary. So typically what happens is a parent or grandparent opens the account and names a child or other loved one the beneficiary. Each plan is sponsored by an individual state, and although you don't have to be a resident of that particular state to invest in its plan, it's best to consult with a financial advisor. We do this all the time, just in terms of looking at the different states' plans. They really do vary in terms of what they offer, how highly they're ranked, and it's important to go in with your eyes open to pick the state that's best for you. In some states, if you're also a resident and you're investing in that state's plan, there can be some tax incentives to staying in state, but it does vary. And these plans have no income or age restrictions, and the upper limit on annual contributions is usually around $300,000. So this is the amount that you can contribute to the plan, not necessarily how much it can grow to, and this varies by state. So getting back to the SECURE Act, here, the existing provisions were supplemented so that 529s now allow something new, which is that qualified student loans up to $10,000 can be offset using 529 plan funds. This is lifetime amount that each person can use to take a bite out of the loan balances that so many recent graduates face. Of course, this assumes there's leftover 529 plan assets once college tuitions are funded. But it's now allowable and a nice option to be aware of, in addition to all of the other attributes that 529s have to offer. Now just a quick note on births and adoptions. In the SECURE Act, there's now a waiver available for the 10% penalty that had previously been imposed on withdrawals that were taken from IRAs to help offset the costs of births or adoptions. You'll still be subject to tax on these IRA withdrawals as you would with any other IRA distributions. And our last slide addresses the kiddie tax. There are many different ways to pass money down to younger generations. Each of these strategies carries its own pros and cons and is really a very personal and customized decision. Before the Secure Act, unearned income of minors was taxed at the unfavorably higher rates used for trust and estates. So this was really investment income predominantly. And now in 2020 and going forward, it's taxed at the parent's top rate. The benefit here is that it takes a lot longer to reach the parent's top tax rate than it does to hit the top tax rate for trusts and estates. So to illustrate this, those who submit their tax returns in 2020 as married filing joint hit the top federal tax rate of 37% at about $612,000 of ordinary income, versus the top federal tax rate for trusts and estates of 37% is reached with just shy of $13,000 of ordinary income. So 612 versus 13,000 is a huge difference, which definitely creates some planning opportunities. However, the calculation of the kiddie tax can be complex, so you'll need your CPA and your financial advisor to assist you, but there definitely is some planning opportunity here. This concludes my prepared remarks. Brad, why don't you go to some questions?
Thanks, Lorraine, for sharing these very important insights. As a reminder for our webinar participants, if you'd like to submit a question, please click the Q&A button on your screen, type in your question, and hit send. Lorraine, we've received a few questions during the presentation, and we'll start with those. So for the first one, I've already started taking RMDs for my IRA, and I'm not yet 72 years old. Can I stop taking those RMDs and start again once I reach that age?
Unfortunately, Brad, no. Once you've started these withdrawals, they do need to continue.
Okay, and the next question that's come in, how does the Secure Act deal with RMDs for 401ks as opposed to RMDs for IRAs?
So in the same fashion as before the Secure Act was passed, all balances from 401ks, SEP IRAs, simple IRAs, and SEP IRAs and regular IRAs must be totaled to determine the RMD, the required minimum distribution in any given year. So just because you didn't roll over a 401k from a previous employer, it doesn't exclude it from the calculation. The only type of IRA that's excluded from distributions of this nature are Roth 401ks, or Roth IRAs, excuse me, as well as Roth 401ks.
Okay, thanks, Lorraine. So the next question that's come in, I'm turning 70 and a half this year. I'm still working part-time and earning consulting income. As a result, I'm able to contribute to a SEP IRA each year. When I turn 72, will I need to take RMDs if I'm still working?
Yes, SEP plan participants who continue employment after attaining age 70 and a half are typically required to take RMDs beginning at age 72. However, because the contribution limits for SEP IRAs are so high, typically in this 2020, they're $57,000. It's up to 25% of your salary with a maximum contribution of 57,000. It can be very attractive to concurrently contribute to your SEP IRA if you have that ability to do so, while taking your RMD that you must take.
Thanks, Lorraine. A few more that have come in. My child has graduated from college and has just joined the workforce. Does it make sense for her to have both a Roth IRA or to have a Roth IRA or a regular IRA? How does the IRA work together with 401k? Is one better than the other?
Good question. Typically, prior to reaching your peak earning years is an ideal time to contribute to a Roth IRA. And the reason for that is because Roth IRA contributions are made with after-tax dollars. These after-tax dollars then are able to compound over time. And of course, you have time on your side if you're new to the workforce and presumably will be working until retirement for 40, 45 years. So there's plenty of time for those dollars to grow tax-free. Additionally, as I mentioned earlier, there are no RMDs for Roths, so they're really attractive from that perspective. An IRA contribution can be made whether it's deductible or non-deductible. There are some income limits to consider, so that's kind of on a case-by-case basis. But if you have an employer that offers a 401k or even a Roth 401k, which actually we offer here at Palisade to our employees, there are just so many options, but the 401k does offer a contribution limit of $19,500 in 2020. That's not counting a catch-up contribution if you're over 50. So that's a higher limit than with the IRA. So, bottom line, if you have the ability to contribute after-tax dollars, I would say the first choice, if available, is the Roth 401k. And then keeping in mind that there could potentially also be a company match. And that's something to certainly ask about and take advantage if it's available.
Thank you so much, Lorraine. That's all the time that we've got for today. To those participants watching at home, thank you so much for joining us and for your confidence in Palisade Capital Management. Please feel free to follow up with us anytime with any questions. And of course, have a wonderful rest of your day.